file for a trial de novo within the 20-day period. Do you think it would stand at $20,000, or would it revert to the $15,000 that the statute indicates?
Superior Court case.
Superior Court case.
Oh, Alex, you just took away one of my good arguments that I was going to make there. Obviously, in a municipal court, the problem would seem to be that the court does not have the authority to enter a judgment in excess of their $15,000 limitation. However, let's assume it's a Superior Court case, and the arbitrator has made, as you've just supposed, Norm, a $20,000 award, and the defense does nothing about it. I think that $20,000 will be entered as a judgment, and that judgment is perfectly valid. And I think there may well be a rare occasion when that might be just fine for all of the parties. I think you might find it to be just fine if, again, you've not done your discovery before reaching the hearing stage, and you've suddenly found something at the hearing that has made this a very surprising case. You're probably going to have a very difficult time in getting any further discovery after the award is in, even if you demand the trial de novo, because you've got to show good cause as to why you didn't do that discovery before. So you may go back to your client and say, you know, on the basis of the information that was turned up, if we went to a trial, the jury might come in anywhere from $17,000 to $30,000. So maybe the $20,000 award by the arbitrator is acceptable in this case. Frankly, I'd rather not be the defense attorney who was in that position of having to sell the $20,000 award to my client, but I think it's conceivable. And I also think, in answer to your question specifically, if you don't object and get your request for trial de novo in within the time frame, that award is going to be entered as a $20,000 judgment.
I think we're all pretty much in agreement that would happen in that fashion. But as Alex, not to steal your thunder, as indicated, you mentioned many times, the chances of that ever happening are rather remote.
Well, sorry, the statute was changed to make express that if the parties stipulate to $15,000, the arbitrator can still come in higher than $15,000. There's a suggestion elsewhere in the statute that if a party waives damages in excess of $15,000, the arbitrator can grant more than $15,000. But I think it'll be a long, long time before we see any of that, and it'll be under remarkable circumstances. But it might not be all that uncommon on the plaintiff's election, where, for example, the judge may have just put a wrong figure on the amount of controversy, and the arbitrator wants to set the record right in that regard.
This is the end of the first half of tape number 2.